All right, let's set the stage. The defendant already pled guilty, but now, during sentencing, he's telling a slightly different story. And trust me, judges hate inconsistencies. Watch closely. This is where credibility can make or break the outcome.
Okay, so Mr. Segur, when you were here and entered your plea of guilty, I asked you some very specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that of your version that I received here in the pre-sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes, ma'am.
You drove to the Taco Bell.
I drove to the Taco Bell.
You stopped at the Taco Bell and you drank while your vehicle was stopped.
Quick legal note. It doesn't matter if you were inside or outside your car. If the keys are accessible and you've been drinking, most jurisdictions still call that physical control of the vehicle. So this explanation, yeah? It's not the slam dunk he thinks it is.
No, ma'am. I was outside the vehicle when the officer.
So you hung out at Taco Bell.
And
drank.
I was waiting for the line to move so I could get my food.
I asked that the defendant be sworn.
Yeah. Let's do that. Raise your right hand. You
Yes.
swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay, so you're saying that you got to Taco Bell. You drove to Taco Bell.
Yes, ma'am.
Okay.
I made a right turn with my signal and everything. Then I was about to park my vehicle.
Mhm.
That's where the swerve came in at. Okay, obviously it has to be. And then so,
I'm not worried about. Hold
yeah.
on.
yes, ma'am.
All right. I want to know, when you got to Taco Bell, regardless of whatever happened,
Right.
did you go through the drive-through or
No.
did you park?
No, ma'am. No, ma'am. I
Listen to
parked-
my question. Did you go through the drive-through or did you park?
I parked my
Okay.
car.
So when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far traffic was up in front of me.
Okay.
They had several cars in front of me.
In front of you for what? You were parked.
Yeah, I was parked like.
Were you parked in a parking spot or were you
No,
parked in
ma'am.
the drive-through?
I was not exactly in the drive-through. I was at the end of the store. At the end of the store,
Okay.
but I guess you could consider that the drive-through line.
Were you waiting for the drive-through?
I was waiting for the drive.
And here we go, the classic wordplay defense. He's trying to out-semantics a judge. Bold move. Judges like her have zero patience for verbal gymnastics, especially when someone's toggling between parked and drive-through line like it's a trick question.
To
Okay,
proceed,
listen,
because-
here's the thing. You're not going to try to trick me up with semantics
No,
today.
ma'am.
Hold on, don't talk over me.
Yes, ma'am.
When I say, were you going through the drive-through or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the
I was
drive-through?
actually waiting to go through the drive-through.
Okay. I may look, I don't know, like I'm 12 years old and just fell off the
No,
turnip
no,
truck,
ma'am.
but I'm not.
No, ma'am. I'm
So
not.
you're in the line and you get out of your vehicle, right? Because
Yes,
there's a long line, the
Right.
cars aren't moving.
right.
Right. So you get out and you decide, I'm going to start drinking here in the parking lot.
No, ma'am. I didn't drink until I got back inside my car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell.
Yeah, I opened the container. That's how the beer came. It was on the floor.
So
of
from the
vehicle.
time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Maybe 15 to 20, 30 minutes, whatever.
Okay. How much did you drink between that time?
I had a malt liquor. The
Mhm.
211 is a strong beer.
Mm-hmm. Just one?
It was a 40 ounce.
Right. So you drank the whole 40
I was
ounces.
drinking out of the thing. After the fact that
You were drinking out of what?
after I stepped back in the car,
Mhm.
I started drinking.
Right.
And
So
then, so
how much of it did you drink?
I consumed a lot of it,
Okay, so let's just say you drank most of
most of it.
1 40-ounce.
It was getting contained.
So that's your story and you're
I
sticking,
think,
hold
yes.
on. So is that your story and you're sticking with it, that you drank most of 1 40-ounce beer in about 15 to 30 minutes and
Yeah.
that you hadn't drank anything before then?
No, except for that night before, about 2 o'clock that morning.
Okay.
And then whole blood, alcohol stays in your blood system, added to what I drank.
Okay, so your test on this night after drinking most of a 40-ounce was 0.188. And you're wanting me to believe that that's based on most.
Let's pause here. A blood alcohol level of 0.188 is more than twice the legal limit. That's not from one drink. The judge knows this. The prosecutor knows this, and honestly, even the Taco Bell drive-thru speaker probably knows this. So what's she doing? She's letting him walk himself deeper into contradiction.
Most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am,
Okay.
but what I recalling my memory, ma'am, I have no reason to try to trick you, Miss West. I'm telling you the God's honest truth. Like I said, I had alcohol in my system from the night before.
Well, how much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if
And
you
hold-
had, hang on, so if you had that much alcohol in your system from the night before, that you were still probably hold on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove into the Taco Bell that later on that evening,
You're not right.
but it wasn't a full 24 hours.
Right.
Right.
So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Yes, ma'am.
Okay.
Here's the turning point. The judge has cornered him logically. Either he was drunk from the night before, which means he drove intoxicated, or he's lying about when he drank. In court, once your story stops adding up, your credibility evaporates.
All right. So let's go back. Obviously, there's some medium acceptance of responsibility, so we can go forward with the arguments unagreed. Mr. Coleman, you have a witness?
Yes, Your Honor. State Cause Troy Robinson.
Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Your Honor, the court's familiar with Mr. Robinson and his background, but
Sure.
for the purpose of the record, Mr. Robinson, you're certified as a fingerprint expert. Isn't that correct?
That's correct.
How long have you been certified as a fingerprint expert?
Almost 6 years now,
Testified in court before?
multiple times.
You've had an opportunity to review some documentation in this case.
I have.
Did they include prior judgments for the defendant, Mark Anthony Segur?
They were.
Yes, I'm showing you what's been marked as State's Exhibit Number 1. Is State's Exhibit Number 1 a fair and accurate summary of the 20 previous felony judgments that you reviewed in this case?
It is.
Using your
For 20 felony judgments.
20 previous prior.
Now, the prosecution brings in their fingerprint expert. Translation: they're about to show this isn't his first rodeo. Watch the mood shift as the record of 20 prior judgments hits the courtroom. This is where sentencing stakes skyrocket.
Criminal judgments, including a number of felonies.
Correct.
Okay. In other words, both misdemeanors and felonies.
Yes, sir.
And did you use the defendant's admission to at least one of the DWIs that he pled true to that had a print on its judgment to compare to the judgments here that had prints on it?
That is correct.
And what was your determination?
They're the same person.
And in addition to the prints that you used to compare and confirm his identity on these judgments, were there also some personal identifying information such as date of birth, SID numbers, and that kind of thing that you used to link to this?
Correct. As known as death bars.
Okay. Your Honor, at this time, I would offer State's Exhibit Number 1, which is a summary of the judgments, and the actual judgments themselves that are marked as State's Exhibits 2 through 20. For purposes of record tender to defense counsel.
Let me just ask, are there any on that list that aren't already on the pre-sentence report? I mean, why are we
It's
doing
been a while
both?
since I looked at it, Judge. I did think that there was at least a couple of those judgments. It's been a while since.
Mr. Burbank, does your client,
I'm gonna,
hold on, does your client have any objection or any reason not to, for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there and the ones that are convictions are any way wrong?
for the misdemeanors, that's correct.
Okay, so what about for the felonies? Is there one, are there one or more that are, he contest?
It's a catch-22, Judge.
Okay.
Because he's pled not true to them so that you'd have the full range of punishment. If-
Oh, okay, so,
Yeah, so it's the 2 felonies that I think are crucial here.
all right, so then do you have any objection to the states, was it 1 and 2?
Judge, it's,
No.
State's 1 is a summary.
I object
And
to
then-
states 1 because I was not given the misdemeanors.
Okay, my main concern
It's
are
the
the felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies would be my concern.
Yes, Judge.
And,
Here's where I'd like to do, Judge. I'd like to admit the summary and just the felonies as a backup, because what I want the court to refer to is the summary. I want to talk about the summary.
well, I want to talk about, I mean, I've got the pre-sentence report. So I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I've got highlights. So if there's something that's not on that already, let me know. If there is, then obviously I will. Are that there are 19 misdemeanor convictions on the pre-sentence report, and that I've got 8 felony convictions.
I think I don't have 8, Judge. I think that there's at least one of them that was refused. If you refer to the